My name is Carl Pearson. I'm an attorney and I have been fighting foreclosures for quite a while. A major development has occurred which I want to discuss with you. It involves all foreclosures, past and present, any state, judicial and non-judicial foreclosures, and what you can do right now to protect yourself and or recover for a wrongful foreclosure. I am able through local counsel to represent homeowners in any state to go into court and seek a remedy for homeowners who have been or are presently being victimized by the filing and use of falsified affidavits by banks, attorneys, mortgage servicing companies, and others in commencing and maintaining foreclosure actions, or when banks sell mortgaged homes under deeds of trust. Here are the facts based upon which I am producing this video entitled False Affidavits Homeowner Lawsuits. Major banks such as Bank of America and JPMorgan Chase and other mortgage lenders such as GMAC have been signing and filing false affidavits in foreclosure actions in the judicial foreclosure states. All or some of these problems took place. The person signing the affidavit did not actually review the papers and transactions upon which the foreclosure action was based. The signatures to the affidavits, both the affiant and the notary, were applied by a machine, tens of thousands a day. The notary public did not actually witness the signature and was physically located in a different city or state from the person signing the affidavit for the bank. Now, for homeowners involving judicial foreclosures, that is where the bank files or filed a foreclosure action in the court, here is what you could do. Number one, if the home has already been sold, so if you have already lost your home through court-ordered foreclosure sale, you could commence an action for damages caused by a wrongful foreclosure by the bank, and also seek punitive damages which cannot exceed 9 times the amount of your actual damages under a recent U.S. Supreme Court decision. You can include in your damages such items as the cost of moving to another residence, higher costs of schooling of your children, damage to your credit rating, losses suffered by your children through disruption of their education, wage or business losses attributable to the foreclosure and sale, and various other items we can identify in a discussion between you and me, including consequential damages resulting from the falsified foreclosure action. But if a foreclosure action is pending now, and you are in default, and your home is not yet sold, it's a slight difference. So if a foreclosure action is pending against you, and you have failed to answer the complaint, your home has not yet been sold, and here is what we can try to do. Make a motion to dismiss the action, or alternatively to vacate the default and let you defend the action, and to seek some of the same type of damages if the action is dismissed. If the action is not dismissed and you are permitted to defend the action, our effort would be to try to obtain a modification agreement for you at a price you can afford, which reflects the actual value of the property. We would attempt to do this by asserting a variety of defenses that you may have, including the lack of standing of the bank to commence its suit against you, title defects, often including MERS, that is the Mortgage Electronic Registration System, in which title is given to MERS, which a court has held has no standing to sue. Or 3, if a foreclosure action is pending and you are defending the action and there is no final order for sale of your home, you should move to amend the answer and assert various defenses, including the defense of a falsified affidavit, upon information and belief, if this appears to be appropriate from your litigation files. You should put in a claim for punitive damages and for wrongful foreclosure, which might be premature, but included anyway as a warning to the bank. Also, you want to initiate discovery in this foreclosure action through requests to admit, requests for document production, the service of interrogatories, and by taking depositions, to obtain as much information as you can about the extent of the bank's fraudulent use of false affidavits. both as to your action and as to all other foreclosure actions by the same bank or its predecessors during the past several years. This litigation tactic may well convince the bank to give you a reasonable modification agreement and permit you to continue living in your home at a lower monthly expense. Now, I want to talk about non-judicial foreclosures and how to take advantage of the bank's use of false affidavits. So, item 4, the foreclosure and sale has taken place already. If you have already had your home sold out from under you in a non-judicial foreclosure by the bank or other lender, I suggest that you commence an action against the foreclosing bank or other lender and any title company for wrongful foreclosure, based upon the known facts that the banks are failing to review the files carefully before commencing foreclosure actions, presumably the same as to ordering non-judicial foreclosures. Seek damages and punitive damages, and if possible, seek to have the property conveyed back to you. You might also sue any new purchaser of the property, especially if the new purchaser is a financial institution. 5, you are behind in payments, and non-judicial foreclosure sale has been threatened by the bank. If you are behind in your payments and the bank or mortgage owners are threatening to sell the property in a non-judicial foreclosure sale, you could commence a declaratory judgment action against the bank or other owner to declare your rights and stop the sale during the pendency of the action. It would be best if you could bring the payments up to date, at least during the first 3 months of your action, to avoid any motion for and imposition of a bond requirement on you by the court. Your declaratory judgment action would allege many of the same matters that constitute defenses to foreclosure actions, including whether the bank owns the original of the note and mortgage, whether the bank has standing to sell your property, the false affidavit scheme of which your threatened non-judicial foreclosure is a part, and seek punitive damages, actual damages, and consequential damages for a wrongful foreclosure attempt. 6, no threat of foreclosure, and you are currently making your monthly mortgage payments. If you are current in making your monthly mortgage payments, you are even in a better position to bring suit against the bank, a declaratory judgment action similar to the preceding analysis. You don't have to worry about a bond, and your lawsuit could well result in a reasonable modification agreement for you. Of course, you need to have grounds similar to the grounds discussed above, and it would be better for the proposed action if your property has less value than the amount of money you owe in the mortgage and any home equity line. The lawsuit would attempt to get your mortgage in line with the present value of the property using legal arguments and the bank's falsification program as part of the argument on your behalf. So in summary, it now seems to be the right time to obtain some measure of justice against the banks through filing an action against the bank in a non-judicial foreclosure state, or trying to defend or open up an existing or completed foreclosure action in a judicial foreclosure state, or pursuing a wrongful foreclosure action in any state where the property has already been sold. I can represent you in any state with local counsel. Please give me a call to discuss your situation and to receive an estimate of the cost. I do not charge for these consultations, and you'll wind up with a much better understanding of your options, whether you decide to do anything or not. I look forward to hearing from you. Here are my website and telephone number: carlperson.com, 212-307-4444. Thank you.